Good morning, Olamide. It's a beautiful Thursday morning, and we're winding down to Friday. Unfortunately, I don't have Eshamomo on set, which is his favorite day of the week. But of course, I will continue as always. Good morning, Nigerians. And attention, once again, is turning to Benue State, where the All Progressives Congress is facing fresh debates following its primary election. Allegation, counterclaims, and differing interpretation of the party's candidate selection process have fueled discussion among party members, political observers, and the public, raising questions about transparency, internal democracy, and what lies ahead for the party. As the conversation continues, many are asking what the controversy means for the APC's unity in Benue, whether the disputes could alter the party's preparation for future elections, and what legal and constitutional provisions apply when disagreements emerge after party primaries. It is a conversation that extends beyond politics, touching on electoral law, party regulation, and the democratic process. And to help us make sense of these issues, we are joined this morning by Barrister Marvin Ibem, a legal practitioner and a public affairs analyst. He will share his perspective on the legal dimensions of the post-primary controversy, the options available to aggrieved parties, and what the unfolding developments could mean for the APC in Benue State. It's good to have you on our program, Mr. Ibem.
Thank you so much. Good morning,
You're welcome.
Good morning, viewers.
The APC conducted primaries, which was monitored by INEC, announced winners, and later replaced several of them through an internal appeal process. Well, legally, can a political party overturn votes cast by its members without conducting fresh elections, or does that amount to substituting political preference for democratic choice?
Okay, thank you very much. Before I delve into the substance of the matter, let me first of all, lay a foundation for the discourse. The issue of nomination of candidates by political parties is a question of law. It's guided by the Constitution and the Electoral Act. And the moment candidate is nominated by a valid primaries held by political parties, it can only be substituted, or substitution can only occur on two grounds where the law provides. Number one, the law provides that where a candidate is validly nominated by a valid primaries, the substitution of such a candidate can only be, number one, either death or voluntary withdrawal. Voluntary withdrawal would mean that the candidate voluntarily, writes, a notice of withdrawal or a letter of withdrawal, from the race. That is the only situation where a candidate can be substituted. But however, a political party cannot willy-nilly, on its own, remove or substitute a candidate after a valid election has been held, primary election has been held. That is unconstitutional. That does not comply with the provisions of the Electoral Act. And if the court is asked to intervene, it will not stand.
Well, since the party says this was done by internal appeal process, were candidates informed or carried along through this process before their names were substituted, or they just got to hear it as everybody else?
Well, it's very funny when people, when people perform or do things that are illegal, and then they begin to ascribe it to internal affairs of the party. When you refer to internal affairs of the party, it does not amount to a reservoir of illegality where anything goes. Internal affairs of the party must conform or complies with the provisions of the law. It must comply with the provisions of the Constitution. It must comply with the provisions of the Electoral Act. And so once any action of the party contravenes the provisions of the Electoral Act and the provisions of the Constitution, it cannot stand. So party cannot on its own arbitrarily remove the name of a candidate, be it by appeal process or whatsoever. Now, if, for instance, there is a disagreement or a dissatisfaction from the conduct of a primary in a political party, or by a political party, so to say, the only avenue that is left for an aggrieved party is to approach the court. It is only the court that can determine or ascertain whether the provisions of the law is followed duly or whether a candidate is validly nominated or not. but a situation where a political party sits, or members or leaders sit from the comfort of their homes, and then begin to remove the names of candidates, willy-nilly on their own. It is totally abysmal. It is totally unconstitutional. It is an illegality of the highest order. And if the court is asked to intervene, it cannot stand.
So if aggrieved members decide to approach the court, just as you've said,
yes,
what would this mean for your party, especially the fact that, elections are just around the corner?
Well, it's actually a very dicey situation because, like I have said before, the law sets the guidelines. The INEC also has its guidelines. And these guidelines are also, to be carried out within a specified time frame. For example, the INEC guidelines set up a timetable wherein the nomination of candidates must be carried out within that specified time frame. And once it is not done within that specified time frame, it means that there is no compliance with the with the guidelines. And also, as it stands, the issue now has degenerated to a level where it looks like an albatross. An albatross in the sense that it is now a burden on the party. And this is an issue that, when you look at it critically, it is an issue of great concern. It is an issue that the party must, toe the path of wisdom at this point in time to address it, because it's almost looking like everything is in disarray. Because, why did I say so? Because this is a process that was supervised and monitored by INEC. Because the new Electoral Act makes it mandatory for INEC to monitor the conduct of party primaries. And so once a party primary is held under the monitor or the supervision of INEC, the political parties cannot now turn around, so to say, and then begin to remove or substitute the names of candidates that have been validly elected by a democratic process. And so if that is done, it is wrong, it is an illegality. And once the court is asked to intervene, the court will intervene and it will not stand. So my own advice is that the leaders of the party must come to, to a round table and have a conversation, a very honest and sincere conversation. Because, like you have rightly mentioned, Benue, the issue of Benue is particularly, a very dicey one, because the candidates that were substituted had emerged through a valid primary election, supervised by INEC, and then after some times, there was this news that candidates have been substituted for no reason, no valid primary was held, nothing happened, and then all of a sudden you wake up, the next day you hear that this candidate name has been substituted. So this is not in accordance with the law, and it is very, very, very illegal, and it should not stand.
So if INEC monitored the process and yes, at the instance, the party adjudged it to be a free, fair, and transparent process, shouldn't INEC be questioning the upturning of the party or changing of names with regards to an internal, or is it audit now, or an internal appeal process? Shouldn't it be asking questions before substituting names, or calling, those that were judged the winners of those elections to ask what happened and carried out his own internal audit before substituting names?
Yeah, well, the role and duties of INEC are clearly spelled out under the law. It is never the responsibility of INEC to begin to delve or to begin to question how political parties come up with names or how political parties manage their affairs. It is not the responsibility of INEC. And so INEC stands and remains as an impartial umpire. So it is only when the the political parties brings up the names of candidates, INEC accepts. It is not the responsibility of INEC to begin to question why the name of candidates is removed from, the list of validly elected or nominated candidates. It is not the responsibility of INEC. It is purely the workings of the party and does not have any connection with INEC.
So since your party is claiming to have done a transparent process and, the appeal process, it says, is quite constitutional, and you are insisting that this is an undemocratic court process, who should the public believe?
Well, the law is very clear. The law is very clear. It is there to be seen by the blind, and everybody knows what the law is, even if not everybody. Now, no matter what they say, no matter what they do, it does not change the provisions of the law, and it is quite clear. Now, whatever you do, and then you garnish it, and make it look like it is legal, no matter how well you do it, once it is not in conformity with the law, it cannot stand. For me, I am personally of the view that the substitution of candidates, as has been done in Benue State, and especially, some other states all over the Federation, Kogi and some other states. For me, I strongly believe that is not in accordance with the law. This Electoral Act, the new Electoral Act, specifically makes provision for the process of nomination, the process of substitution of candidates, and also, most importantly, when a primary election is to be held, the Electoral Act has made it mandatory. It is not a question of choice for INEC to monitor. And now, these primary elections were held under the supervision of INEC, and candidates emerged, no matter how it is. So it does not lie on the party to now, on their own, begin to remove or replace validly elected candidates on the altar of appeal or resolving an appeal. If you ask the question, was there any primary election that was held before then? Was there a decision of the court that are seek for the removal of these candidates? So, what I am saying in essence is that the party cannot on its own begin to remove the names of candidates that have been validly elected through a democratic process. And lastly, let me say, when this Electoral Act was signed into law by the president, we were all happy because the old Electoral Act of 2022 was not explicit as to give INEC that power and that responsibility to compulsorily monitor the conduct of primaries of political parties. But right now, that the new Electoral Act makes provision for it. And once a primary is not monitored by INEC, once a primary does not conform with the provisions of the law, it will not stand. It is not a primary, and it cannot be referred to as a primary election.
All right, we'll still come back to these issues. There's still more to talk about, but that'll be right after the short break. Don't go anywhere. We still have more. Stay with us. We'll be right back. With us now, we're still evaluating the post-election substitution of candidates in Benue State, and still with us is Mr. Ibem. Now, let's talk about the rivalry between Governor Akume and Governor Alia and SGF Akume, because on the May the 3rd, before the primaries, the both duo announced a reconciliation. But we saw that after that, the rivalry reopened. Now, would you say that this reconciliation was genuine, or it was simply a temporary ceasefire ahead of candidate selection?
Well, first of all, let me say that I am not, or I was not a part of that reconciliation, move or whatsoever. And I am not involved in anything regarding or concerning the reconciliation. But, however, what I think is that the governor of Benue State is the governor at this point in time. And for me, I think he should be allowed to rule, to govern the state, and then deliver the dividends of democracy to the people of Benue State. Like you have rightly mentioned, the secretary to the state government, to the federal government, is a former governor as well. He has had his 8 years tenure as a governor of Benue State. And now, another person, Governor Alia, is the governor. And I think no matter the political disagreement they may have, the governor should be allowed to govern the state. I'm not really or willing to delve into the political disagreement between them because I don't know what transpired. I don't know how their relationship has broken up to this level. But I know for sure that prior to Alia becoming the governor of Benue State, I know he was strongly supported by the SGF to becoming a governor of Benue State. But however, having emerged as the governor of Benue State, me think that the fact that the people of Benue are happy with the governor, the fact that the governor is delivering the dividends of democracy to Benue State, I think that alone should supersede any political disagreement whatsoever. Because for me, I think that these things are distractions, so to say. They are distractions, and the governor must be allowed to do his work. The governor must be allowed to govern the state. I'm not willing or ready to delve into the disagreement between the both of them because I am not a part of it. I don't know what transpired, and I'm not willing to delve into it. Thank you.
It's difficult to say that you don't want to delve into the controversy between the duo because they are the big wigs in Benue State. But let's move ahead. Before the primaries, the SGF Senator Akume reportedly advocated for the retention of 7 elected officials, while Governor Alia insisted that all aspirants should go to the ballot and test their popularity. Did the post-election reversal effectively achieve the automatic ticket arrangement that members had rejected at the ballot?
Okay, when you look at it very well, you will understand or you will see that the process of candidates' emergence in primary election must be democratic. It is not something that one person will sit down and say, you return, you don't return. It must be by a democratic process where the will of the people will prevail. Now, a primary election was held by the APC in Benue State. It was held all over the country, and candidates emerged. So, it is not morally or legally right for somebody to say, these are the candidates that must go. These are the people that must be allowed to go, regardless of whether they were supported or not by the people. I do not think that is right. Once candidates emerge through a valid and constitutional democratic process by primary election, the candidates must be fielded as a candidate of the party. So, trying to now diminish, that process or the credibility of that process through which those candidates emerge, and then trying to impose the people who you want, to be the aspirant or to be on the ballot, and then try to impose them on the party and on the people. For me, it is morally incorrect. It is legally incorrect.
Well, with George Akume being the secretary to the government of the Federation and one of Benue's most influential politicians, even without direct proof of intervention, does the restoration of several politicians associated with his camp create a damaging perception of federal influence?
Well, this is politics, and everybody is trying to get what, when, and how. And so it is a game that every party is playing. And so you cannot expect, these people or the camp of the SGF not to also fight for the retention of power within their camp. And these things that are happening, they are expected. They are highly expected. And like I said, that is not an issue that I want to critically delve into, because you cannot begin to delve into what you are not a part of, what you do not even know how it even began and how it is going. Yes,
since you don't want to delve into the issue of George Akume and Governor Alia, perhaps you might want to delve into the former governor of Benue State, Gabriel Suswan, who was defeated by Senator Emmanuel Udende in the initial Benue Northeast primary, but was later removed. What specific irregularity was attributed to Suswan's victory, and what was it serious enough to invalidate the entire results?
Well, you see, the issue of the former governor of Benue State that you have mentioned now is one of the wonders that up till now, some of us have not even been able to comprehend what actually happened or what actually transpired. Because I remember very well, when primary elections were held, the name of Suswan came up as one of the persons that won the APC senatorial ticket in Benue State. And that name was rightly submitted to INEC after the primary election. And so, for the party to now come up to say that the name of Suswan has been removed, or Suswan has been removed as a validly nominated candidate, via the primary elections in Benue State, it is completely abysmal. And I think, if I were Suswan, sincerely, I'll challenge it. I'll go to court because clearly, he won from the primaries, and he has been wrongfully substituted. And so he has a right to approach the court for remedy. And the court have consistently frowned at such situation or circumstances where a candidate who is elected via a valid primary is wrongfully removed. The court takes serious exception to such situations. So for me, I think if I were Suswan, I will approach the court.
All right, with all these irregularities you've just mentioned, should the APC publish the full primary election appeal committee report so that members can see the allegation, the evidence, and the reasoning behind every reversal? Okay,
now that boils down to the issue at hand. If the appeal panels or committees, for whatever reason, makes any findings of irregularity in the process of the primary election, should that automatically amount to a victory for the complainant? The answer is no, it does not, because the law have set out clearly the guidelines through which a party, a candidate can emerge, and which is via a valid primary election, monitored and supervised by INEC. So if for any reason a political party finds out some sort of irregularities in the nomination of a candidate via the primary election, I think what is up for the party to do is to conduct another primary election and let another candidate emerge. The law does not give the party a power to willy-nilly, on its own, remove the name of a candidate after a valid election has been conducted. It does not. And so that is how it should be. A party cannot just remove the name of a candidate and say, we have heard an appeal. So how did the person become a winner? Was another primary election conducted? Did he come out with the majority of the lawful vote cast at the primary election? So what are the indices considered before declaration of the complainant or petitioner, so to say, as the winner of the primary election? So completely, that is an illegality. And if the court is asked to intervene, for me, it will not stand.
And does this expose deeper cracks within your party in Benue State?
Well, like I said before, it is a very unfortunate situation. Very, very unfortunate situation. And for me, I would advise the party to tread carefully and revisit the situation and remedy the wrongs that have been done. If not, as it is, if that wrong is not remedied, it is more like I said, an albatross that is hanging on the neck of the party in Benue State. And the time to act is now. The time to resolve it is now. There are dangers ahead. Thank you.
Well, in calling for them to review their standing, are you saying that they should resubstitute the names of the aggrieved people or call them to a round table for reconciliation?
For me, there is absolutely no reason for the substitution. There's absolutely no reason. Because even if there are complaints from the conduct of the primaries, it does not give the party the power to remove the names of candidates that have emerged. And so, even if for any reason you are removing a candidate, like I said, it must not be by the decision of the party, because a valid primary has been held. It must either be by conduct of another primary election or by the decision of the court, because the aggrieved party should actually approach the court on the fact that the primaries did not conform with the provisions of the law, did not conform with the Constitution, did not conform with the Electoral Act. And on that ground, the court can intervene. The court can even declare the aggrieved party a winner. That is the law. But for the party, on its own, after the primary election has been held, to remove it, it is totally unacceptable. It is totally unlawful.
Yes. Thank you so much, Mr. Ibem. We'll definitely keep our eye on the status of your party in Benue State and what lies ahead for your party. Thank you so much for your contribution.
Thank you so much. Thank you so much. Thank you. Thank you.